Speaker, in the 16th of December 2009 Cabinet paper from the Minister of Police and Corrections, changes to the Sentencing and Parole Reform Bill, the Ministry of Justice has noted, and I quote, "The deterrence effect of the three-stage regime is uncertain. The proposals will add substantial direct costs to the justice system without creating any significantly improved outcomes in terms of reducing the drivers of crime, improving social outcomes or reducing reoffending and victimisation." The Department of Corrections has also said in its report to the Law and Order Committee, further information requested by the Law and Order Committee regarding prison bed forecasts received on the 5th of March 2010, there is an implicit assumption that the bill will have no deterrent impact. And I think that those reports from the two departments now advising on this matter are of significance for the quality of the debate that we now have to have. Obviously, the government challenges the opposition on the basis of saying that this is a measure that proves that they are tougher on crime than we are. And I would just want to say to this House that it is not a competition. I am deeply concerned about a government that proceeds with a measure such as this when the Minister of Justice and the Minister of Māori Affairs are attempting to engage with the broader community who have an interest in these matters to try and find some way of addressing those underlying drivers of crime in an environment where we actually can have a debate about the things that will make a difference in the long term without having to be challenged on something that we know is not an effective deterrent and which the government knows is not an effective deterrent as well. And I think that the other problem that I have with debating this measure before we've had a response from the government on the ministerial meeting on the drivers of crime that they held last year, in fact just over a year ago last month, that was when they had the ministerial meeting, and we still yet have not seen the fruit of the work that people put into that and the subsequent work that has been done ever since. And I know that one of the areas of work is around this whole area of reoffending, because our reoffending rates are pretty appalling. And I think one of the reasons why our reoffending rates are so appalling is because of the lack of work that is done around rehabilitation and in fact directing people away from the prison system at a very early stage. There are people ending up in our prison system too early and without that level of intervention that one would expect. So let's go through the circumstances of one gentleman who ended up in the category that was defined by the Minister, brought up here in New Zealand. I'm not sure of his age now, so we're going back into the 1950s, but his father saw it, was stepfather, actually saw it fit to tie him to the kennel in the backyard as a punishment for his constant bad behaviour inside the house. So he thought tying him to the dog kennel would actually be a good way of getting him to behave well when he was inside inside the house. So this child ended up with an entirely look, Mr. Speaker, I accept the fact that the member concerned is the driver behind this bill, but to have I'm not going to name an individual in this House. Okay. I'm just going to have to ignore this barrage of interjections from somebody who actually doesn't want to hear the example that I want to use. What I wanted to say was that when somebody has been brought up in an environment where they actually do not learn empathy, they do not learn any of the behaviours that we would take as a norm, where they actually don't have the capacity to form close relationships because they have not bonded with a significant adult at any stage since they were born, then we are as a society responsible for growing monsters, not for growing healthy young men with healthy attitudes and the capacity to form loving relationships. When a child has only ever seen his father beat his mother to a pulp, it's really hard to think about how he is going to have a good relationship with a woman in the future. So we have an intergenerational problem in this country, and we don't just fix it by saying, here is the mess, the disaster that has been created in the lives of some people, and let's just lock them up for what they've done. Let's not try and see whether there is some degree of humanity left within this individual, to see whether there is some potential for redemption, whether there is some potential for rehabilitation. And I actually think that that is what is missing from this debate completely, is that there are people who have the capacity to change. And all I'm saying is that by removing the discretion that sits with the judiciary and allowing the judicial system to simply impose a sentence because certain previous offences have occurred, won't do anything to reduce the drivers of crime. It won't improve social outcomes. It won't reduce reoffending, and it won't reduce re-victimisation, as the departmental report to the ministers and to the select committee did identify. Mr Speaker, as we know, this bill has had a report from the Attorney-General with respect to it being questionable in terms of our obligations under the Bill of Rights. And the reason that that was the case was because it was found to be providing for disproportionately severe punishment. And of course there are different messages that can be taken from the legislation, because it really will depend on the order in which certain offences are committed in order to get this disproportionate impact. The regulatory impact statement that accompanied the original bill said the bill would be disproportionate, expensive and impact most severely on Māori, and I know that the Māori Party have a very strong view on this matter. It is very well accepted that a Māori is much more likely to be stopped. A Māori is much more likely to be arrested if stopped. A Māori is much more likely to be charged if arrested. He is much more likely to be charged with a more significant offence if he is charged. He is much more likely to be convicted if he is charged, and he is much more likely to get a longer sentence than an equivalent individual who is not Māori if he is found guilty of that offence. And that evidence is out there for everyone to see. This will make it worse. This is about putting more Māori in prisons when we really ought to be addressing why we have so many of them there now, because they are disproportionately represented in our statistics, as we all know. Mr Speaker, the trouble is that this is one of those bills where it is designed to say, it's designed to send a message about what the government is doing. Unfortunately, the message that it is sending is not backed up by any evidence anywhere in the world. This is not an effective way of addressing the issues the government says that it's trying to address. And I think that that is unfair, not only on this House and on the people of New Zealand, but also unfair on those that have been working very hard to try and address those underlying drivers of crime, because that's where we know we can make the most substantial difference over the long term. Short-term, quick fix never works. This has never worked in any jurisdiction internationally. All of the evidence that have been put up in relation to the three strikes policies in the American jurisdictions don't stack up when they're actually investigated, and I think unfortunately this is predicated on a flawed foundation, and I don't believe that it should proceed any further.
Sandra Gowdy.